All right, welcome everybody. My name is Joseph Barnett. I am a partner at Wolfstorff Rosenthal, and I am here with partner Vivian Zhu and Robert Blanco, a senior associate attorney. We're here to discuss the new EB5 waiting line estimates and other new EB5 information. There has been a lot of information and data given to the EB5 industry over the past couple of weeks by USCIS and by the Department of State. And we want to share that with everyone and give some of our predictions about what is to come. So I will, I guess first, just maybe we can give a little bit of background about ourselves. I've been practicing in EB5 for about 8 years now. My main area of practice is project side EB5 work, exemplar applications, 829s, but it also has to do with representing immigrant investors and making sure that they are placed in good projects where they can get their green card and achieve that immigration success.
Hello, my name is Vivian Zhu. I joined the firm in 2014, and before that, I was a securities attorney. And my job is primarily with working with the EB5 clients and investment immigrants clients.
Hi, I'm Robert Blanco. I've been doing this for about 5 or 6 years now. I work mostly with EB5 investors filing their I-526 petitions and doing their immigration work. I've also done a lot of work with people who are already here in other non-immigrant statuses and have other types of green card applications pending. So we'll talk a little bit about how to make decisions based on the EB5 timing when you have other things going on as well.
And just a little bit about our firm. I'm going to let you read that. We don't have to read it for you guys, but we are headed by Bernard Wolfstorff in the EB5 area. He is the managing partner of the firm and former president of the American Immigration Lawyer Association. We do not have his cheerful South African accent, but we got the same information as he does, and we are in a good position to provide that to you. And so we are about to take you through the PPT from sunny and bright Santa Monica, where it's 70 degrees and beautiful, and just rubbing that in a little bit for you guys in the north. All right, so let's move on to what you guys are here for. These are the 5 topics that we're going to be speaking about today. Generally, we're going to be talking about EB5 visa allocation. We're going to be talking about some of the recent changes in EB5 visa number use and predictions in the upcoming visa bulletins. These predictions are based on data that has been provided by Charlie Oppenheim, who is the chief of the visa control within the Department of State, who presented last week at the AILA IIUSA EB5 Industry Forum. And so now we're kind of providing this to everyone worldwide. Then we'll also be able to provide some guesstimates regarding EB5 visa waiting lines. Obviously, this is not a science, and certainly we aren't going to say that these are guarantees or anything like that, but we've done a little bit of analysis into the numbers ourselves, and we'll be able to give you some insight from what we have gleaned on that end. And then finally, we'll be talking about the most important thing, achieving EB5 success and making sure that whether it's you or if you're a regional center attorney, your clients are able to get their green cards and get that lawful permanent residency. So the first slide that we have here today is pretty much an overview of EB5 number use for the past 6 years or so. And I kind of want to talk just generally about EB5 visa allocation first, and then we can kind of get into why this slide is important. So every year, the Immigration and Nationality Act allocates 140,000 immigrant visas to the 5 employment-based categories, EB5 being one of them. EB5 gets 7.1% of those 140,000 visas. So that's 9,940 visas every year. Of those in the law, in the statute, 3,000 of those are reserved for investors who invest in a targeted employment area. But as you can see, a good majority of EB5 investors already invest in projects that are located in targeted employment areas. So that provision of the law isn't too applicable these days. But the interesting thing here is that 10,000 number that you always hear, oh, there's 10,000 visas that are allocated every year. It's not actually 10,000. And if you can see, if you look and add up all of the columns for each year, you'll note that for most of them, it's over 10,000. Recently, though, in the last fiscal year, I believe that number was under 10,000. And because of that, not all of those visas were used. And we'll get to some of the ways that they can make sure that all of those visas are used going forward. But the interesting thing that I like to see is that, there's about 1 million green cards are issued about every year or so. And less than 10 or only 10,000 of them come through EB5. It's a very, very small percent of the total number of immigrants who get to come to the United States come through EB5. And then additionally, on top of that, there is a per country cap of 7%. This is based on your country of birth, not your country of citizenship. And that is where you get that 700 number from if you've been following the EB5 news. 700 is 7% of 10,000. It's really 696. That's 7% of the 9,940. But even more importantly is that for China, they actually start at even a lower number because of this Chinese Student Protection Act back right after the Tiananmen Square protests. So actually there's very few EB5 visa numbers, if any, allocated to China. And what we'll explain later is that they kind of get the leftovers because their priority dates are earlier. And so we're going to get into that a little bit more. But I kind of wanted to bring it to Vivian and Robert to talk about, because those visas were not all used in the past, what has USCIS and the Department of State done this year to hopefully use up all of those visas?
We saw that they opened up Chart B. I think they firstly introduced the concept of Chart B in 2015, and they opened up Chart B this year again. And Chart B is also called the date for filing. So what it means is that I'll probably introduce a little bit about the priority date, because everybody who filed EB5 will get a priority date when you file the 526 petition. And priority date is usually the date that you submitted your 526 petition. And it is also your place in the waiting line. So imagine you're waiting outside a restaurant, ready to get in. And the waiter, once the table is available, the waiter will call you and to lead you into the restaurant and feed your food, right? And then the priority date is basically your spot in the waiting line. And if you look at your 526 receipt, it will show under the case number. So why the priority date is important is that every month the U.S. Department of State will publish a visa bulletin, which is an updated waiting list for all the immigrants who are subject to the visa quota system. So, for example, in the November 2018 visa bulletin, under the final action date, the Chinese EB5 cutoff date is August 15, 2014, which means Chinese nationals who filed their 526 before August 15, 2014 has their visa number available. If you file after this date, you have to still, wait for your visa numbers to be available. But due to the long waiting line, the priority date becomes extremely important, especially for Chinese nationals. If you say, if your 526 get denied, or if you withdraw your 526, you lose your priority date. Even if you refile, you get a new priority date, which means your waiting line restarts. So, so we're talking about the Chart B date for filing. They only opened Chart B in 2015 and this year, 2018, in October and November, which means if your priority date is current under Chart B, you may file adjustment of status if you're eligible, meaning if you're holding a work visa or a student visa in the US, you can file adjustment of status. But you'll be your adjustment of status will still be pending until your Chart A, the final priority date, to be current. But it does opens the door for people who are already in the US to get a work permit and travel permit while you're waiting for your final action date to be current. So
yeah, that's a good point. Actually, I want to go to the next slide here, because this shows that the number of EB-5 visas that are used for those who are in the United States filing an adjustment of status versus those who are outside of the United States and getting an immigrant visa through consular processing. And that red bar is the number of adjustment of status applications. You can see that that's growing every year for the past couple of years now. And what's nice, sorry about that.
And I think that will continue to grow as more and more of the EB-5 applicants are people who are here. We're seeing that a lot with people from India who are already here on H-1Bs, and other people who are planning, you know, once they're already here, to start the EB-5 programs. I think that the percentage of people filing adjustment of status applications will continue to increase.
yeah,
There is a big distinction, though, about using Chart B that I just want to be very clear about. Although it does give you that right to work in the United States, your adjustment of status application, like Vivian mentioned, will not be approved until that Chart A opens up and your priority date becomes current. And likewise, there is no age out protection using Chart B. And so if there are those backlogs that you're concerned about, we're going to talk a little bit more about aging out later, that would not be solved with the Chart B filing.
and the benefit of Chart B is actually to give the government an idea of how many visas needed in the US. So as we talked about, there are under 10,000 visas issued in the past few years. So they open Chart B to just avoid wasting visas. So they get an idea of how many visas they could, that could be needed in the following year. So you can also consider Chart B an indicator of where this Chart A cutoff date would be at the end of fiscal year. For example, China, Chart B, it shows a cutoff date of October 2014. And as predicted by Charlie Oppenheim, the Chinese cutoff date as the end of fiscal 2019 will be October 2014. So it's sort of like give you an idea of where this cutoff date would be for the next fiscal year end.
Look into the future, if you will.
Right.
Absolutely, absolutely. So this next slide here shows a very interesting trend that has completely flipped in fiscal year 2018. The blue columns are the number of EB-5 visas who have been given to China mainland-born nationals in the past 5 years. The orange is the rest of the world. And so even though I was talking before about that Chinese Student Protection Act and the lack of visas available for Chinese in the beginning of a fiscal year, because there are so many leftovers that are not allocated to individuals from other countries, they have historically been able to get most of the EB-5 visa use. But as that orange column continues to climb and climb, that means that there will be less visas available for Chinese nationals. And the importance with that is that because they have earlier priority dates, Once each country is oversubscribed, meaning they have already given out those 700 or so visas, then everybody else goes behind those Chinese nationals who have earlier priority dates. And so that in itself can be a startling issue, something that is not always understood. And so, we kind of liken it to leftovers. The leftovers are going to the Chinese, and they're going to eat all of the leftovers up so that there are none left over for Vietnamese and potentially Indian nationals in the coming years.
Right. This kind of just underscores the slide before it, which is just showing that if you look at all of these individual countries other than China, their percentage usage of EB-5 numbers in fiscal year 2018 increased for most of them substantially. And so what I think is important with this slide too is that this is technically demand that started years earlier when the I-526 was filed. I-526 filing times, or adjudication times, are about 2 years right now. So people who used visas in 2018 filed their I-526 petition probably in 2016 or maybe 2017. And so this trend is continuing today even. And so we expect that these numbers will continue this trend when we look next year at the number of visas used in fiscal year 2019, for example.
Right. And, with the waiting line in China right now, we've heard that it's very difficult to incentivize EB-5 investors out of China. And because of that, regional centers are now heading to other markets. And as those other markets get more developed and investors start coming in and filing their applications, visa use will go to them, which means there will be less leftovers available for the Chinese who are sitting in that backlog. That's what we call ROW, rest of world. And this slide, the rest of world means everybody other than those listed, but in general, most of the time, when people say rest of world, it's either not considering China or maybe not China and Vietnam, those countries that are backlogged. So this here is the current visa bulletin, chart A. And as you can see here, there's a couple of interesting things. One, you see, like Vivian mentioned, that the cutoff date or the final action date for China mainland born is August 15th, 2014. And for Vietnamese, it's February 1st, 2016. This shows, like Vivian mentioned, when your priority date is before these dates, you are able to move forward. Interestingly, I also want to point out for India that all of the other, and I guess China as well, is that EB1, 2, and 3 also have backlogs. And so those are other visa classifications and eligibilities to get those types of visas. But EB5 is not the only visa that is experiencing these backlogs. It's a very, what's the right way to put it, common part of immigration practice is advising clients and working through these backlog issues.
So even if we can see the cutoff date for Chinese is 2014, it doesn't mean that the waiting line is only 4 years. So the government will publish this visa bulletin every month, but they do not necessarily move the cutoff date forward every month. Sometimes you'll see like the cutoff date stops for several months and then move for 1 month or for a couple of weeks. It's all depending on how many visas they have at hand, and they have the visas available for each categories, for immigrants under each categories, and people from different countries. I remember from October 2018, the Vietnam was January 2016, so they moved it forward for a month. But for Chinese, they only moved maybe 1 week or two. Mm-hmm. Yeah. So as you can see, this is just an indicator of which people can have their visa numbers available.
And sorry, just before you go ahead, no, go with the slide. I was just going to say is that, a lot of this stuff that Robert's about to mention, a lot of this comes from Charlie Oppenheim. And so we want to give a gracious thank you to him for being so open, for giving this data to the EB-5 industry so that investors and families and regional centers can, plan, especially on the investor side. They need to make sure that the children aren't going to age out, that they will be able to achieve their immigration goals as a family and not have some children be left behind.
Absolutely. Yeah, we're very grateful that Mr. Oppenheim has been so accessible and willing to share as much as he knows, because we've talked about before, there are a lot of variables that can change things over time, but this is what we know as of last week. So the December visa bulletin should be out in the next few days. Mr. Oppenheim anticipates that the final action date for China will be August 22nd, so move forward a few days. And then he gave us some best and worst case scenarios for September 2019, which is a year from now at the end of this current fiscal year. We're in fiscal year 2019 right now, started in October. So this is the end of this fiscal year. The best case scenario is that the China final action date moves to October 22nd, 2014. The worst case is that it moves to October 8th. So it's not a big range, but that's about what we're looking at and what we can expect to see over the next 10 or 12 months. Basically, we're not expecting a very fast movement because there are just so many people who filed I-526 petitions in 2014. Usually around regional center program sunset dates. And so it just takes a while to move through all of that demand.
And what Charlie has indicated is that, and correct me if I'm wrong, that I think he said there are about 3,800, he predicts,
right,
visas will be given as leftovers this fiscal year to China. That's his estimate.
So when we talk about the 10,000 that we talked about before, and then each country uses 700 of their maximum, and then China gets all of the leftovers. Mr. Oppenheim is anticipating that there are 3,800 of the leftovers that China will get this year.
And those 3,800 visas will be going to those who have filed during this limited period of, say, August to October of 2014.
Right. So then we have some predictions for Vietnam. We're expecting some continued movement in this next month's visa bulletin to May 1st, 2016. This is consistent with what has been going on at the start of the fiscal year. Mr. Oppenheim anticipates that the final action date will continue to move forward, hopefully until get to September of 2016 in the next few months. And then at some point in about May or June 2019, the Department of State will have issued all 700 of Vietnam's visas. And at that point, they will move the final action date back to track with China. And that's very logical that they would do that because, as we said before, the only visas available then are leftover visas, and the leftover visas go based on when your priority date is, so that's going to match the China date. Then at the start of the next fiscal year, October 2019, we expect to see a big movement forward again, just like we did this year from September 2018 to October 2018. We expect the similar jump in the final action days for Vietnam. And this pattern will continue until the earlier Chinese cases are cleared out.
And the big difference here with Vietnam and potentially India compared to China is that significant jump when the beginning of every fiscal year starts.
Right. China will not benefit from a big jump at the start of the fiscal year in the same way that these other backlog countries will.
Exactly.
So we'll go on to India. As we said before, India is current today, but it's not going to stay that way. Just based on the demand for Indian EB-5 applicants the last year or two, There will be a backlog starting. They're expecting sometime in the summer, no later than July of 2019. That date, when they first establish it, will probably match the China date, just as we said for Vietnam. And they'll stay that way for the rest of the fiscal year. But then in October of 2019, just like we talked about for Vietnam, we will expect the Indian final action dates to jump again, jump ahead because they'll have a new 700 available to them. And Mr. Oppenheim anticipates that final action date could be sometime in 2017 at that point. So hopefully that will continue to go. But again, we'll have the same pattern that we just talked about for Vietnam.
Also, I want to mention that Vietnam and India also are still current under Chart B. So if you're a Vietnamese or Indian national located in the US on work visa or student visa, you may get a chance to file under Chart B for the adjustment of status. If that's the case, you're welcome to reach out to us because we've been filing a lot of cases like that. Mm-hmm. So we would love to give you advice, or you're welcome to ask questions regarding your eligibility to file adjustment under Chart B.
That's right. And the one thing that we see with India that we don't see as much with China and with Vietnam is demand for EB-5 visas for people who have already established demand for EB-2 green cards. And so most people know that the Indian EB-2 backlogs are very, very long, the longest of any really in the employment-based categories. And so a lot of our Indian EB-5 applicants have filed EB-2 applications years and years ago and are wondering, well, what's going to happen? How long will it take for my EB-2 to be current versus my EB-5 to become current? And that's also a difficult to estimate. But Charlie Oppenheim told us at the conference last week that he knows about EB-2 demand representing 14,000 applicants, 14,000 visa numbers in the EB-2 category that have not yet used a number. And so it could take up to 5 years to process those 14,000 EB-2 numbers. And those all have priority dates around January 2011 or earlier. So that just gives a little bit of an idea of what Charlie's looking at in the EB-2 category versus the EB-5 category.
And so just to answer some general questions on that, which we get all of the time, they're wonderful questions. If there is a backlog, you can absolutely still invest your 500,000 or your $1 million if you're not located in a target employment area. You can still file your I-526. USCIS will still adjudicate your I-526. It's just that next stage of the process, you are not able to move forward until a visa is available. And then, the other thing that I kind of just wanted to say about this here is, there's a waiting line for India EB-2, and there's a waiting line, will be a waiting line for India EB-5 at some point. And so the real question becomes is which waiting line is longer? And is it worth that $500,000 to move up in that waiting line by, depending on what your priority date is, a certain number of years? And so that's usually the calculus that our clients go through before they make that EB-5 investment decision.
And for some people, that's really easy. If your EB-2 India priority date is 2016 or 2017,
right, yeah,
that could be decades in the EB-2 category, and we are not anticipating anywhere near that long for the EB-5, even if you were starting today. So it really depends on your individual circumstances. What is your EB-2 priority date? Talk to us and we'll decide whether EB-5 really makes sense for you. Oops. Did we skip one?
That's it.
Okay. One of the reasons EB-5 waiting lines are so important, other than the fact that people want to get their green cards and start living in the United States and just move on with their lives, is some of these issues that we've identified. One of the biggest ones is age outs for derivatives. So the rules require that your child, in order to get a visa, qualifies as a child if he or she is under 21 and unmarried. But we have to have them get the visa before they turn 21. Once they turn 21, they age out. Now, we can sometimes subtract the amount of time the I-526 petition is pending based on the Child Status Protection Act. But that only helps us if we are able to lock in the derivative beneficiary's age. And we can only do that once the final action date, once the petition is current based on the final action date.
Chart A.
Chart A. So the age out dilemma for some people, you know, they're watching that final action date because that's when they can lock in their child's age before they age out. Another issue is longer investment terms. You know, the EB-5 capital cannot be returned until after the completion of the conditional residency period, which doesn't start until your priority date becomes current and you file either an adjustment of status or you obtain your immigrant visa. So for people who are stuck in a backlog, their funds will remain invested for longer. That brings up
at-risk requirement that your EB-5 investment capital must be sustained at risk throughout the 2 years of conditional green card status.
Right, and that brings up the redeployment issues, which, you know, your money has to remain at risk. That's what Joe was talking about. So we really want to make these issues aware, you know, people aware of these issues beforehand, because these are issues that will come up not today, but maybe a few years from now.
Right, because we got the question from clients every day that, will my child age out? So I think it's, you know, it's a case by case situation. So if you can send us your priority date, your approval date, and the date of birth of your child, we can do the math for you. It's quite complicated, but we can give you a date that your child will age out if the priority date doesn't become current. So you can get an idea of how likely your child will age out. And another thing is the priority date retention. As we mentioned, that the priority date is very important because of long waiting lines. So as mentioned by the new IPO director, Sarah Kendall, that under the current law, you're not allowed to substitute your children. You know, it doesn't allow the parent to substitute children as principal applicant and retain the priority date. So if you want to change the principal to your children, you have to refile 526 and the waiting line restarts. So that really sucks. And another question is, because Chinese people are using, because of the long waiting line, the Chinese people wanted to file under their children's name. So the minor children sometimes have to be the principal applicant, which bring us the issue of, you know, the capacity for a minor child, like 2 or 3 year old, to enter into a civil contract of $500,000 US. And the immigration is issuing RFEs on that and saying the contract signed by minor children are not enforceable. Therefore, the investment is not committed. So that's another issue. And some, you know, sometimes the death of the principal brings another issue, because, you know, like only at the time of death, if one of the derivative beneficiaries live in the US, you can, you know, keep the application going. You can continue file the application as, you know, as to inherit the priority date. Otherwise, the approval, even if the 526 is approved, the approval is automatically revoked at the time that the principal applicant passed away.
And so you can see that there are just a lot of issues that arise because of these waiting lines. And to be perfectly honest, because this is such a new development in the industry, there hasn't been too much guidance from USCIS on how projects should be using EB-5 capital. That's what the redeployment issue is. And, you know, some of these other age out concerns, whether it's the death or children being aged out, these are very, very complex immigration matters, sometimes involving both the Department of State and USCIS. And so it's incredibly important you have experienced immigration attorneys to help you through these. I do see a couple questions that we have. One is whether the C in the visa bulletin means current. Yes, that's exactly what it means. It means that at this time, in this month, there is no backlog for that particular visa category and that country. The other question that we have is, what month do we have? In 2019, at the beginning of the new fiscal year, what will the India cutoff date be? And no one really has the answer to that question too much. Charlie has indicated that it will likely move at some point to 2017. So again,
it's about all we know.
That's really all we know.
That the final action date should be sometime in 2017. But these estimates will change over the next 10 or 12 months. This is what we know today, but things will happen. More I-526s will be approved. We'll have better visibility into the demand. We'll see how many visas are used by each country in this category over the next few months. And as we continue to get more and more data, the estimates will continue to change. So
but it's very likely that the India Chart B will still be current in 2019 because even if the Vietnamese Chart A priority date is 2 to 3 years from now, their Chart B is still current. So we expect that the India Chart B cutoff date will still be current next year or in the near future.
Right, because the Indian backlog is still far less than China and less than Vietnam. Right.
And so your spot in the waiting line when you file, this is good, is also based on the number of visas that are going to be issued before you. And that means that you need to have an approved I-526. And this chart here shows average approval rates of I-526 petitions. And you see here that India is significant, well, not significantly, but it's lower than the national average, 87% versus 92%. So you would be able to, just because a certain number of I-526s were filed, that doesn't mean that they will all be approved and that visas will therefore come from those applications. That's something that I just want to point out here. And so
one of the many variables that go into these calculations and our guesstimates.
And why is India approval rates lower than worldwide average? I think it can come from a couple of reasons. One, I think just in general, there is a prevalence of sort of the black money market in India and their economy, so that could have some issues with it. The other is that source of funds come from a variety of sources rather than just one source normally when it comes with an Indian investor. So, even if one source isn't well documented, there can still be issues on the source of funds. Another reason may be that the source of funds are fine, but the project, you had a cousin who wanted to open up a hotel and the project just didn't move forward. That could be another reason why. And then, also it's, there's been there's been a market in India where CPAs or maybe Indian attorneys are doing the source of funds work at a lower cost.
Rather than an immigration attorney.
And so, you penny wise, pound foolish, you pay for what you get. I don't think we've had any 526 denials by any Indian nationals.
I think so.
So, like I said, you kind of pay for what you get.
Yeah.
Another aspect of that waiting line is the number of
derivatives,
family members, as opposed to the principal applicants.
Right. So from this chart, you can say that China, so like the nationwide average is like 3 people per case. And for Chinese, it's, a little bit more than 3. Vietnam is about 4 people per case. In India, because most of the Indian applicants are located in the US and they have children born in the US. So it's usually just the mom and dad. India would have 2 applicants per case. This is also an influence factor for how fast this waiting line can move for each for people from each country. As you can see, for Vietnam people who have bigger family, like they would use more visa numbers as compared to the number of cases they get the visa number every year. So for Vietnam, the movement would be slower as compared to other people from other countries.
Right. So because every I-526 petition uses more than one visa if there are family members, the number of family members is a pretty important variable when we're doing these kind of estimates and when Mr. Oppenheim gives us these estimates.
And so, sorry to jump in here, but the other thing is that, people give estimates online all of the time. They look through their own calculations. There's so many assumptions that need to be made. And this is just one of them, 4 visas per Vietnamese I-526, 3 visas per Chinese I-526, 2 visas per Indian I-526. Those are just assumptions, and that they impact all the calculations. Likewise, how many leftovers are going to be available? Is it 3,800? Is it 3,500? Is it 3,000? As that demand from the rest of the world grows, there'll be less leftovers for Chinese. And so, again, these are all just variables that, frankly, nobody has the answers to at this point.
Right.
And so now for the big kahuna, the moment you've all been waiting for. I'll let Vivian, you want to take over on this one?
Well, this is obviously like the big slides in the Chicago conference that surprises everyone, because last time when Charlie gave the prediction, China was 15 years, and somehow it's now 14 years. So a lot of people are questioning his math. No, we're just basing, I believe he does have the best information available, and this years of waiting is based on his calculation on how many visas are needed for people from each country and how many visas they get each year. So,
and to be clear, this is the waiting time if you start today.
Right.
So if you are filing your I-526 petition today or last week at the conference, this is Mr. Oppenheim's estimate for how long it would take to get the green card, including the amount of time the I-526 petition is pending. So clearly, if people who are already in the waiting line, if they've already filed their I-526, if they're have an I-526 approved and they're just waiting for their priority date to be current, each individual waiting line will be less than what these estimates are.
Yep.
And the other thing that's important to notice or to note is that for all countries other than China, this represents what Mr. Oppenheim considers the worst case scenario. So these waiting lines could be less, they could theoretically be more, but these represent conservative estimates from Mr. Oppenheim.
And I think part of, and again, it seems logical to me that part of the reason why that China mainland born was decreased from 15 to 14 is that he may be thinking that there are more leftovers available than he had previously indicated. So the number stays the same. It's just the division. What is that number that it's being divided by? How many visas per year are going through? If you increase that, that number is going to go down.
The demand for China EB-5 numbers is what it is.
Right.
But however many they get every year will change that waiting line.
Yeah, for example, in 2018, China got 4,500 visa numbers. So if we keep getting 45 visa numbers every year for China, the waiting line will be obviously less than 14 years.
Right.
But if we get only like say 25,000, then the waiting line will get longer.
Right.
So nobody can predict how long exactly the waiting line is.
Just depends on the supply and demand for other countries.
Exactly. Yeah. So now we're going to talk obviously about these waiting lines. We've talked about some of the issues that come with it, and so what are some of the solutions to this, and what are reasons to be somewhat hopeful if you are thinking about filing and looking at these waiting lines today?
Right. So there's been a number of different bills proposed in Congress to change the way we count visa numbers for EB-5 individually and for all employment-based categories. And the one that would have the largest effect would be if they didn't count derivatives. If they didn't count derivatives, then we're just looking at the number of I-526 filings, and that would greatly decrease the waiting times for a lot of the countries, especially for the countries that use more visas for derivatives like Vietnam. That's been proposed a number of times in different avenues, so we'll see if anything happens with that. There's also pending litigation going on right now to challenge specifically the counting of derivatives for the EB-5 category. There is quite a bit of legislative history that suggests that when Congress created the EB-5 program, they intended there to be visas given to 10,000 investors, not 10,000 investors and family members, because they anticipated that there would be 100,000 jobs created rather than a lesser amount. So that's currently pending. If that litigation were to be successful, that would obviously have a very big impact for the EB-5 category, just like the legislation would.
One other thing about the legislation is I have seen, or at least it was in last year, I'm not sure, I think it's now an amendment about just removing all per country caps for all employment-based categories. I think there was an HR 392 last year or maybe 2 years ago.
Right, it's like the Fairness Act or something like that.
And so I think that also has the potential for changing all of these waiting lines. I know there's arguments on both sides of the aisle on that one, but it's another piece of legislation or part of an amendment to a piece of legislation that we are all watching.
Right. So another solution, I mean, we talked about Chart B quite a bit. Chart B, if it remains open, which it is for the last few months.
It's going to move it to Chart B.
Yeah. These dates are obviously better than Chart A. So if we can continue to file adjustment of status applications based on Chart B, that would be a significant benefit for a lot of people who are here in the U.S.
Notably, even though Department of State issues Chart B every month, it is solely up to USCIS on whether they will accept applications to or pursuant to Chart B.
Right.
And so there is a website that USCIS publishes normally soon after the issuance of the visa bulletin, indicating whether or not that Chart B is open or whether you are able to only move forward under the Chart A.
Right.
Sorry about that. Just wanted to,
Yeah, and so then the solution, which we talked to a little bit earlier, is just adding your non-immigrant visa strategy into the EB-5 strategy. So everybody's case is different. Everybody has unique circumstances. And we feel it's really important to talk to an immigration attorney to say, look, I want to go to school, or I have a job offer, or whatever it is, to work in your non-immigrant visa strategy with your EB-5 strategy, because one will affect the other. And we may be able to structure a non-immigrant visa strategy that allows you to start living and working in the United States before you have a green card, and will make that wait line, that backlog, a little more tolerable.
And also, even if you do not have a waiting line under EB-5, you probably want to get a B1, B2 visa before we file the 526, because after you file, you may not get the visa anymore because of the immigrant intent.
Right.
So we usually advise our clients to get a visitor visa if you want to visit the US while your 526 is pending. It's more beneficial for you to get it like right now after we file.
and this is incredibly important and something that both the consulate is going to be looking at is, have you represented the truth about your non-immigrant visa when you're applying for that EB-5? They're looking for inconsistencies. They want to make sure that you had that non-immigrant intent when you entered on a non-immigrant visa, unless it's a dual intent visa. And so, those are issues that our clients face on a daily basis that we need to advise on. And so again, another reason why you should have an experienced attorney helping you out throughout this process. It's more than just filing the 526.
Right.
It's helping you or your clients out throughout that entire immigration process. And so I guess this gets to kind of our sort of the end of our webinar here. Achieving EB-5 success. Obviously, there's a lot of projects out there, a lot of information out there in the United States, online on the internet. And so it's important that you do your due diligence on an EB-5 project. I cannot stress that enough. EB-5 is a job creation program with an immigration benefit. So if the project that you invest in doesn't create those jobs, well, then you may not get that immigration benefit. So doing your due diligence, making sure that the business plan will be executed and that those jobs will be created is a very, very, if not most critically important aspect of EB-5. And so I highly recommend you talk with your financial advisors, whether it's a broker dealer, your own tax advisors, immigration attorneys. It's a huge decision, not one that should be lightly, and we're always here to help with that kind of stuff. The second aspect, I guess, Vivian, you want to talk about the source of funds?
Yeah, I think the source of funds, like the approval rate we have just seen in the previous slides, I believe those are a better indicator of which country's source of funds is more likely to get approved or not. And these days, the USCIS is issuing more and more RFPs and notes on source of funds, and they're also doing a lot of overseas investigation on the investors' backgrounds and whether the documents they provided are genuine or authenticated. So it's very important to document your source of funds, to retain experienced immigration lawyers to give you a better source of funds strategy. Like, even if you have the money, it doesn't mean that your 526 will get approved, because the government will check if you have sufficient documents to show the source of those money.
Or they'll look at your prior B visa applications.
They would pull out all your records with the US government. Anything you told the government before, they will compare those records with your 526 filings. If they find any inconsistency, they will issue an RFP that's like 13, 15 pages these days. So it's like you gotta be careful with your source funds and the documents you submit to the US government.
Yeah, those I think are the big two. And I guess the third one that I should have put on there, which is self-serving, is retain Wolfstorf Rosenthal, because you absolutely will achieve EB-5 success if you guys work with us.
You want to answer the third question on the board? So basically saying he has a EB2 priority date in 2013. If after the 526 is approved, can he file adjustment of status? So the eligibility for filing adjustment status is actually depending on, one, whether they open Chart B, meaning whether USCIS is going to use Chart B for filing. If they open Chart B and you're in the US on H-1B visa and you have a 526 approved and the India Chart B is current, you can definitely file adjustment if you're eligible. There are other factors that to determine if you're eligible, like whether you had any out of status or whether you had F1 reinstatement. It's quite complicated. So you're welcome to contact us and we can do an evaluation for your case.
We got a question here. What is the likelihood of the litigation regarding derivatives and whether or not that will be successful or not?
I think it's a pretty difficult question to answer.
Yeah.
There's no question it's going to be difficult, but some of the best litigators in the immigration bar are working on the case. So
yeah, I think it really has to do with this interpretation by the Department of State of the statute and whether or not they should have gone through a rulemaking process to do this, or whether or not a court should defer to the Department of State's interpretation of the statute. I think the one thing that the government has going for it is that that's how it's been done for many, many years. On the other hand, just because it's been done for many years doesn't mean that it's been done correctly or lawfully. And so that's what the judge is going to have to decide.
Mm-hmm. Okay, well, I think we're close to the end of our time.
Yeah.
So thank you for joining us. We hope that you found some helpful information in this presentation. You know, I think it goes without saying, but please feel free to contact either of us if you have questions about your individual circumstances, your case, your immigration strategy. We would be happy to talk to you, happy to meet with you, and hopefully we can help. Thank you very much. Have a great day.
Thank you. Take care.